Mr. Moderator, we're being recorded and do we have everyone online now?
Everyone's on the call.
Thank you so much. Good evening, everyone, and welcome to the Borough of Carteret Zoning Board meeting. Today is April 16th, 2024, and the time is 6:30 p.m. I'm sorry, 6 p.m. Would everyone please join me in the Pledge of Allegiance? I pledge of allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Justice. Thank you, everyone. This time, Lauren, can we have the roll call of board members, please?
James?
Here.
Black?
Here.
Pelly?
Here.
Benko? O'Connor?
Here.
Chen?
Here.
Patika?
Here.
Lohman is excused. DuPont?
Here.
Jardim?
Here.
Curran present.
Thank you, Lauren. Counselor, can we have the reading of the open public meeting notice, please?
Yes, good evening, Chairman and members of the board. This is a regular meeting of the Zoning Board of Adjustment of the Borough. The notice requirements of the Open Public Meetings Act have been satisfied in the following manner. At the annual reorganization meeting of the Zoning Board, a resolution was adopted setting forth the time, date, and location of each scheduled meeting to be held during the current year. Copies of the annual meetings notice were provided to 2 official newspapers of the borough, and 2 additional copies were forwarded to the clerk for filing and for posting in a public place. A copy of the annual meetings notice and any revisions thereto shall be mailed to any person who requests it and who pays a fee established by the governing body to cover the expense of that mailing.
Thank you, Counselor. Tonight we have one hearing, one case. It's ZB-23-01 DSV Air and Sea Inc. Last month they were adjourned to without notice to come to tonight's meeting. Do we have Counselor online for the DSV?
Yes, good evening. Luke Pontier of the law firm Day Pitney here this evening on behalf of DSV.
Thank you, Counselor. Mr. Jardine, do we need to swear in the Counselor?
No, Chairman, just as witnesses.
Just as witnesses. Okay, Counselor, please proceed.
Thank you. And Mr. Chair and Mr. Jardine, would you prefer that we swear in the witnesses at the outset or as they begin to give their testimony?
Typically, we do it as they begin their testimony.
Yeah. Great. Again, Luke Pontier of the law firm Day Pitney here this evening on behalf of the applicant. The applicant is the tenant of property located at 800 Federal Boulevard, and that's designated on the borough's tax map as block 2801, lot 6. That property is located in the LI light industry zone where warehousing is a permitted use. We're here this evening for a few different aspects of our application. And as part of that, we're seeking a zoning code interpretation as to our current and proposed use of the property, as well as a minor site plan approval, and if needed, a use variance to permit the use of our building as we propose herein. So the property currently contains an approximately 600,858 square foot warehouse building, which again is a permitted use in the LI zone. Tonight's application really focuses on an approximately 1,000 square foot portion of that building. So in other words, we're talking about less than 0.25% of the building. That's really the subject and the substance of tonight's application. At a high level, the applicant is seeking approvals to construct control areas within the existing building to store quantities of certain materials that result in an H3 building classification. The International Building Code classifies buildings based on their contents and the quantities of those contents, and you'll hear more about that from our architect in his testimony this evening. The main question for this board, and at the outset, and we'll get through our testimony, is whether the storage of materials that are classified as H3 triggers the need for a use variance as part of this application. As I mentioned, there are three parts, and they're all interrelated. So the first part is the interpretation of the code, where we're asking the board to determine whether the use of the property is a permitted principal use in this zone, and whether the proposed interior improvements and the items that will be stored within the building changes the principal use of the property to a use that is not permitted. We are also seeking site plan approval for the interior fit out to establish these three control areas, a portion of which where H3 substances will be stored. And these improvements will be constructed in accordance and to meet the standards of the Uniform Construction Code and the New Jersey Fire Code. And then again, if needed, based on the outcome of the zoning code interpretation, we will seek a use variance to permit the building to store the requested materials and to perform these improvements. We did receive one review from Mr. DuPont, and that was dated March 18th of 2024. With me this evening, I have three witnesses. I have a representative of the applicant who will take you through the property and the operations that DSV has on site and how the materials flow through the building and what types of materials they do store there. We'll then have our project architect testify about the specific improvements that are proposed, and he can get into some more details about the different building classifications. And then lastly, we have our project planner, and he'll provide both the reasoning for why we do feel this remains a permitted use, but in the alternative, he'll also provide testimony as to why a use variance would be justified in this instance. Notice was published in the local newspaper and mailed to property owners within 200 feet, both in accordance with applicable law, and an affidavit of notice and mailing was provided to the board prior to this evening's hearing. As mentioned at the outset, we were originally scheduled for a hearing on March 19th, but this application was then carried on the record without the need for further notice to this evening. So if there's no other preliminary matters that the board would like to address, we can get started with our first witness.
Chairman, I just want to get a clarification from Mr. Pontier as to the interpretation. So you're going to present witnesses on the interpretation?
So we plan to present all three of our witnesses together, starting again with the applicant representative, then the architect, and then the planner, because we feel that regardless of the decision that the board makes on the interpretation, that the testimony, particularly of the applicant and the architect, will be necessary for the board to really understand how the property is used, whether or not this is a permitted use or a use variance. So we're not necessarily splitting up our testimony. We propose to get all the testimony out there and then have the board deliberate and make its decisions if that's acceptable to the board.
Yeah, I just want to make sure. So you're going to address specifically section 160-135 of our code, that is the light industrial zone regulations, correct?
Correct. And there is I believe it's one of the prohibited uses under that code that talks about, the danger and hazardous substances. So that is absolutely correct. That's the interpretation that we're seeking.
Okay, and that's specifically G2 under that section 160-135. That what your applicant or your planner is going to address, just so we're clear.
Our planner will specifically address the interpretation question. Yes, our applicant will provide testimony that details what the operations are that our planner will then rely on.
Okay. Thank you.
Okay, and so our first witness is going to be Christine Claremont, who is a representative of the applicant. I believe she is on with her video on.
Yeah.
Correct. Hello, good morning, or good afternoon, everybody.
Good afternoon. Chairman, should I swear her in?
Please, Counselor.
Okay. Ms. Claremont, will you raise your right hand? You swear the testimony you'll give this evening will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Very good. And Ms. Claremont will be a fact witness for us this evening, so no need to go through her credentials. But Ms. Claremont, if you could, for the edification of the board, please provide the name of your employer, your position with the employer, please.
Yes, the name of the employer is DSV Air and Sea Logistics, and I am the director of the Air and Sea warehousing operations throughout the U.S.
Great, thanks. And could you just describe a little bit for the board to understand what DSV is, what their services are, and specifically what they provide in Carteret?
Correct. So DSV Air and Sea Division overall for the U.S. provides global logistics services for our clients, mainly import and export logistics, as well as warehousing related typically to the importation and exportation of goods. For the Carteret facility, because it's located at a couple of main airports and seaports, what we do there is predominantly cross-dock activity, so importation of goods, and then within a couple of days typically goes out delivery to final clients. Same from an export perspective, freight's received at the warehouse. We consolidate it for either air freight or ocean freight consolidations, and it ships out typically overseas. There are some cases of business within the Carteret facility currently that would be some, what we would say, like some storage, some contract logistics opportunities for some different clients that we manage directly.
Okay, thank you. And can you just describe your history and your relationship to the property that's the subject of the application?
Yep. At the Carteret facility, we've been there since August 2022. We've been in the area between Port Reading. We moved into Carteret from Port Reading back in August 2022. Prior to that, we were in Port Reading, which was just across the highway, and we had been there for about 10 years.
Okay, very good. And so what renovations were made to the facility, upon your first moving in back in 2022?
We had to get several things up to code, electricity. We had to obviously install the DSV standard from an IT and security perspective with the CCTVs. We also did some renovations throughout the office facilities just to make it usable for our specific needs. We had to expand some door docks to support some larger trucks or trailers that we would receive for loading or offloading. We also had to do some sprinkler work for some of the hazardous material freight that we would be handling in that facility.
Great. And so I think it would be fair to say that, DSV was not the first tenant in this building. It's clear that the building has been around for quite a while, correct?
Correct. Yeah, I believe the previous tenant might have been in the facility for about 30 years prior. Not entirely sure, but they've been there for quite a bit.
Very good. And what would you say is the percentage based out of the Carteret facility of the operation that involves hazardous materials?
Less than 10% overall. It's a 300,000 square foot facility. Most of what we do is non-hazardous. There is a component that will be hazardous. Again, we treat it more as an in-transit cross-dock that comes in with just regular freight and typically routed for export consolidation.
Okay, very good. And is there any long-term storage of high hazard materials, or is it more in line with the cross-dock operations that you're describing?
More in line with the cross-dock operations.
And can you just describe a little bit about how that compares to a long-term storage? So what's like the average lifespan of a product that comes into the facility?
It could be anywhere from a couple of days to maybe a week. Every now and then there could be something there for longer, but typically our average in-transit freight is there 72 hours.
So it's mainly that someone is coming in, it's a good was imported, a truck is picking it up, bringing it to your facility, and it's really only sitting there so that another truck or another form of transportation can come pick it up and bring it elsewhere. Is that
correct? In most cases, yes.
Very good. And can you describe the types of actual packaging and hazardous commodities that you handle on site?
Sure. It can vary from small cartons to large drums of material. It could be lithium batteries, so that could be under the classification of class 9. Could be some class 8, which could be some marine pollutants. Could be, I think, class 3 is kind of what's prompted this, and that's some of the flammable goods that could come in kind of some of the small packages as well as the large drums. There are certain commodities that DSV as a company does not handle for hazardous goods, at all, such as radioactive material.
And just to get a little bit more descriptive onto what those goods actually are, so that the board can understand that although they are high hazard, they're also materials that we think of every day, right? So that could mean fragrances or cleaning products. Is that correct?
I think particularly for some of the class 3, it could be because it's some flavorings. Ultimately, when it comes into the warehouse, we might not necessarily know the actual direct use or the end use of it. We have the MSDSs that are provided at the time it comes in, which unless you're a chemical engineer, you might not understand exactly what it's specifying, but we know that some of the material for the flammable in particular is ingredients used for beverages.
Okay, and can you get into a little bit more detail about the process for actually handling the freight at the facility and in terms of the personnel on site and how that works?
Sure, specific for the hazardous or just general freight?
Both, if you could
Okay,
describe
yeah.
generally and then any differences
Yeah.
that are put into action for the hazardous.
As a general rule, the freight comes in, we receive it into our WMS, so we're doing a quick inspection of just, what it is, how did it come in, where is it from? And then we're marking a few things into our WMS application, our warehouse management system, just for inventory receiving purposes. If something is hazardous, there'll just be an additional marking that we'll check to verify that it's hazardous, yes or no. And then if we have the MSDS available, then we'll file that. If not, then we'll have to go to our business team to ask them to compile or collect that MSDS information for us for the hazardous goods. We keep that information, it's tracked in our WMS until the time that it ships out. At that point, then there's a status, a milestone for the good shipping out. So while it's in the custody of the facility, it's typically stored based off of, is it rackable? Is it small cartons? Is it hazardous? There's a designated area for the hazardous freight. And until at such point it's scheduled for distribution.
Okay, I have no additional questions for you on direct. Is there any comments you'd like to make in addition to the testimony you've provided?
No, not that I can think of immediately.
Okay, so I'd like to invite the board and any professionals to ask questions related to Christine's testimony.
Thank you.
Thank you, Counselor. Mr. DuPont, do you have any specific questions of the expert witness?
No, I think her testimony is consistent with what Ms. Claremont had told us before. It's a small percent of hazardous materials, but it is in fact on site. So no question this time.
Great. Does anyone on my board have any questions of the expert witness as to their testimony?
The fact witness.
Yeah, fact witness, thank you. As hearing nothing from the board, Mr. Jardine, are you okay to proceed with the next witness?
Yeah, Chairman, I do have just a couple quick questions for Ms. Claremont. Ms. Claremont, you mentioned that in most cases, hazardous materials are not long-term storage and therefore not there for more than 72 hours.
Correct.
So there are some uses, there's some hazardous materials that are stored for more than 72 hours on site?
There could be, yeah.
And
Specifically what those are, or how long they are, it would be case by case basis, but a general rule, even from a company perspective for the US, is that our general handling process for the US is to have hazardous goods, unless there's a determined agreement with the client, typically should be in and out within a 72-hour period.
Okay. And any understanding of the percentage of those that are longer held?
I do not. I
Okay.
would probably say less than 25%, but that would just be an estimate.
Okay. And then some of, you said the term hazardous several times, and I'm going to use some other terms.
Sure.
Are any of the uses, and this will be based upon what your understanding of the term
Sure.
means, are any of the uses toxic?
I feel like there's a classification of some marine pollutants which are toxic to wildlife.
Okay. That
So-
are stored there.
Correct.
Okay. Any of the of what's stored there lethal?
Not that I'm aware of.
Okay.
Or-
And I'm reading from and council probably knows this. I'm reading from our section 160-135, and one of the prohibited uses is any use which may be toxic, lethal, hazardous, dangerous or injurious to the general health, safety, and welfare of the general public. So based upon that definition, you would agree that some of the material that is stored is either toxic or hazardous, or may in fact be dangerous or injurious to the general health, safety, and welfare of the general public?
If I'm interpreting marine pollutant to be toxic, then possibly, but I'd have to look at the markings of what comes up on marine pollutant.
Okay,
to
but you
confirm.
agree on hazardous?
I believe so.
Okay, thank you. Nothing further, Chairman.
Thank you, Mr. Counselor, Mr. Jardine. At this time, I'd like to open up to the public and see if there's any questions of this expert witness. Mr. Moderator, is there anyone in the public?
Looks like everyone is dialed in through WebEx. Anyone wishing to ask a question, please unmute yourself.
I'll ask one more time. If someone would like to unmute themselves from the public and ask any questions, please do so now.
There are no questions.
Thank you. Counselor, please proceed with your next witness.
Absolutely. So next up, we'd like to call our project architect, Mr. Davidson.
Yes.
Do I need to be sworn in?
Yes, sir.
Yes,
Thank you.
please.
Mr. Davidson, do you swear the testimony you'll give this evening will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And Mr. Davidson, for the edification of the board, could you please provide them with the name and address of your firm?
Yeah, we're Vissi Architecture and Design. We're located at 10,000 Lincoln Drive East, Suite 104 in Marlton, New Jersey, 08053.
Great. And could you please provide the board with your education, experience, qualifications, and any licensures?
Yes, I am went to Temple University, have a Bachelor of Architecture from Temple University. I'm a licensed architect in the state of New Jersey, as well as 24 approximately other states in the country. And I have been practicing architecture for 28 years.
Very good. And your New Jersey license remains active and in good standing?
Yes, it is.
I'd like to offer Mr. Davidson as an expert in the field of architecture.
So do, please proceed.
Thank you. And Mr. Davidson, you've been engaged by the applicant as the project architect for this project?
Yes, I have.
And your office submitted the life safety plan that was submitted to the board?
Yes.
Great. And so I'll let you take it away. Can you please describe what's being proposed as part of this application?
Yes. Is it okay for me to share my screen?
Yes, sir.
Yes.
Okay. So what we see on the screen right now is the existing warehouse facility. And what I had done was done a life safety check of this existing facility based on the information that I have, including the racking layout that was present in terms of egress capacity, existing conditions and stuff like that. So I'm just going to kind of go over a summary of this, and then if there's any questions, because at this stage of the game, we're just proposing the high hazard modifications for this application. Everything else is existing. The majority of the space currently is storage and S1 storage use. That's the gray area on the screen. In the blue area, that is like support office, break room areas, conference rooms for the operations. It's pretty typical in this type of use. And up here is, I know there was some violation notices that were sent out last year, which we had reviewed. The proposed areas for the high hazard storage, H3 high hazard, and then some additional control area for some additional hazardous materials that don't exceed the quantities that make it classified as high hazard through the building code and fire codes. Does anyone have any questions on this piece?
I do not.
Okay. I just want to clarify that we're approximating a 2,000 square foot storage for the materials that don't exceed the quantities that classify as a high hazard use, and then about 1,000 square feet of area that would be classified as high hazard, which would require building modifications to comply with the building codes and the fire codes and the UCC.
Just Counselor, this has been uploaded to our portal website, and you've marked this as Exhibit A.
On the next page, this is a list of, this page is, I'm sorry, A001. It's a hazardous materials calculation. The DSV had provided us with a maximum anticipated quantity of hazardous materials that they would have and the different types of those hazardous materials. So they had given us the MSDS sheets as well as an anticipated quantity that they would have as a maximum quantity. So that's these items here, the manufacturer, the chemical name, what it contains, the hazards that it is, the material class, flash point, boiling point, what type it is, and then the quantity that is anticipated to be the maximum on site in gallons. So I can go through all of these, but I think that I'll just save for questions. What we did is then roll those materials into a type of class. So class 1A flammable materials, class 1B flammable materials, 1C, and then 2A, and 3B. And what you'll see here is that there are a maximum quantity per control zone or per control zone with sprinklers, which is what the existing building is. And then if we had a control zone with sprinklers and flammable cabinets. As you can see in the two areas where there is red, we are exceeding the maximum per control zone of sprinklers, and in addition, the maximum per control zone with sprinklers and flammable cabinets. That's what's kicking us into the high hazard use group for this project. The other quantities of the class 1C liquid, we do not exceed the control zones for even a maximum control zone without sprinklers, but the maximum control zone with sprinklers, 240, we are at 110 anticipated maximum quantity. The class 2 combustible materials, we are again allowed 240 gallons per control zone. We're anticipating 12.25. Class 3A combustible, we have 660 allowed and 5.5 anticipated, and then class 3B is 26,400 and 118 anticipated. So those materials we are proposing to store in control area 1, and then the other flammable liquids that we have, which come in there, different packaging will be stored in the control areas 2, 3, and 4. And those are the high hazard use groups, which is 1,000 square feet total, and the, we'll say, more combustible material control area, which is.
Excuse me, 1 second, please. This is the moderator. I would like to remind everyone to please mute yourselves when you're not speaking. There's some noise being created as he's speaking.
Thank you. And this control area here is where we're proposing the remaining storage of those materials that are listed in that chart. And again, these are the maximum materials that we were provided, but understanding that they may be different quantities at different times of each of those materials. So there may never be where they're all stored there at one time, but we don't have exact information as Christine had testified prior to, of how long these materials are going to stay, what's coming in when, and how long it is till it's distributed. So we are taking kind of a worst case scenario and designing the safety systems based off of those quantities.
And Joe, while you're on this screen, could you describe to the board how the building gets its classification? So is the inclusion of some of those high hazard materials in the quantities that make them H3, does that change the classification of the building in your expert opinion, or can the building remain classified as S1?
The building itself would be classified as S1. The areas that are in where the storage of the hazardous materials are is high hazard. These are just the area of the building is just so small to quantify it as its own use as part of the building. It's considered accessory use to the building, and it's about 0.33% of the total. So of the high hazards, it's 1,000 square feet of the total building, which is 302,212 square feet. So it's a very small piece of the building.
Great. And the improvements are being designed in compliance with all legal requirements, the UCC, New Jersey Fire Code.
Yes, that is correct. So there will be upgrades to the building based on this, into fire barrier walls, additional sprinkler needs, as well as ventilation and protection of electrical sparks and stuff. These are all closed containers for storage, so it's not a production environment where there's the potential for these materials to escape unless there is a damaged container.
Okay. I don't have any additional questions for you on direct. Is there any other testimony you wanted to provide to the board?
No, but I'm open for any questions that the board may have.
Great. So I would invite the board and its professionals to ask any questions of the witness.
Thank you. I'd like to start with Mr. DuPont. Do you have any questions of this expert witness?
No, I think the explanation of the plan was accurate. It's exactly what was submitted.
Great, thank you. Mr. Jardine, do you have any questions of the expert witness?
Yes, Chairman, 2 questions. Mr. Davidson, you had said that, in your opinion, the entire building could be categorized as an S1, right?
That's from a building code perspective, yes.
Okay, what is that based on? What are you relying on for that opinion? Are you relying on some regulation or code, or?
Yeah, it's the 2021 International Building Code.
And do you have a site specifically, just so we can have it?
A site meaning?
A citation, I'm sorry.
It would be Chapter 3.
Can you get more specific? Which section?
Hang on.
It's not a test. If you don't know, that's fine.
I can find it. I got my code up. So
I mean, is it saying that there is a percentage of a building?
it's a
that-
mixed use. Yeah, it's mixed use in how you classify a building based on the percentages of various uses. So it's either mixed use, separated mixed use, non-separated, or if the total of the additional uses, right? Each piece of the building is classified per use. If it's less than 10%, it can be classified as the main use of the building, which is storage.
You find that site yet or no?
Hang on, I'm getting there.
So one additional question, and maybe if you find it, that's great. You sort of were talking in terms of what will happen in the future. It's my understanding, though, that this storage is occurring now. Is that right?
I believe all the hazardous storage of that was on site that prompted the violation was removed.
Okay. So it happened in the past. It happened up to a certain time, and now it's not happening.
Yeah, to my understanding, and maybe Christine can kind of comment on that, but I believe that was part of complying with the violation notice was to remove these materials from the building.
We removed the high hazard materials from the building. They're on the exterior of the building.
For what it's worth, do you have a round date as to when that occurred?
So we removed them from the interior of the building shortly after the citation. It would have been at some point after March, April of last year. Again, anything that's considered high hazard, which is really the class 3 drums, as they're being received and we're being received into the WMS, and they're then immediately put into containers that are kept in the yard.
Thank you, Chairman. I don't have anything else.
All right, at this time, I'd open up to the board. Does anyone on the board have any questions of the expert witness? No one on the board. I open up to the public. Mr. Moderator, anyone in the public online, please unmute yourself and ask your question. I'll ask a second time. Anyone in the public want to be heard with this expert witness? Hearing none, close to the public. Counselor, please proceed to your next witness.
Thank you. Our next witness is going to be our project planner, who I think coincidentally also may have found the citation, but
we'll get there, Luke.
Yeah, John, if you want to be sworn in.
Good evening, sir. You swear the testimony that you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
John, can you please provide the board with the name and address of your firm?
Hi, everyone. My name is John McDonough, and that's spelled just like you see on the screen there, MC, capital DONOUGH. And I have my own firm, John McDonough Associates. We're a planning and landscape architecture firm.
Very good. And can you provide the board with your education, experience, qualifications, and any licensures?
Sure. I am a licensed professional planner here in the state of New Jersey. That license is current and in good standing. I'm also a member of the American Institute of Certified Planners, which is a national certification. And I testify on a nightly basis throughout the state of New Jersey, including here in Carteret. I think I was actually the planner on the 900 Federal a year or two ago. It's right across the street.
Accepted. Please proceed.
Thank you. Mr. McDonough, you've been retained by the applicant as the planner for this project,
Yes, I have.
and you've had an opportunity to review the application that was submitted, and you've heard the testimony presented this evening?
Yes, I have.
Great. And can you please provide some testimony on the zoning code interpretation and why we believe that the minimal H3 materials that will be stored on site do not change the ultimate use of the building?
Sure. I think a good place to start here, obviously with the zoning interpretation, is the board has authority to grant zoning interpretations under the land use law, section 70B, as in boy. And the interpretation that the applicant is looking for the board to move on is that this is in fact a permitted use in the zone, notwithstanding the fact that there is some storage of class H3 high hazard materials in there. And so if we look at the stated purpose of the zone that the site is in, this is your LI light industrial district. We know you have two heavy industrial districts as well. This is the light industrial district. And the stated purpose, as I read section 160-134 of your code, is to create modern, and I'm paraphrasing here, modern industrial complexes which do not create hazardous conditions or nuisances on adjacent properties or surrounding properties. I think with the containment here, the relatively small size and small duration of the use, of the materials rather, the use itself would operate within the confines of what the zone contemplates. Again, the language of the zone is use specific, not material specific. And to go to the section of the ordinance that your council had referenced at the outset in terms of what's prohibited, I'm going to section 160-135. Making my way down to subsection G, which talks about prohibited uses. And under G, subsection 6, this is what your counsel was reading before. It says right at the outset, any use, doesn't say material, it says any use which may be toxic, lethal, hazardous, dangerous, or injurious to the general health, safety, and welfare of the general public. I think based on the testimony that you've just heard architecturally in terms of the physical plant and operationally, the use itself will operate within the confines of what the zone plan contemplates, notwithstanding the fact that it does have a very, very small portion that is going to contain these H3 high hazard classification materials. As you've heard, to our architect, it's not changing the building classification under the building code. I'm going to actually yield to our architect to come back and give that code when the time comes. I know there are some tables in the building code that establish maximums on materials, but I think there's a different section that he'll talk to. The short duration of the use, or the materials rather, the very small space, which is actually less than 1% of the zoning, actually less than 1% of the total physical plant. I have 0.003 of this 300,000 square foot warehouse facility will contain these high hazard materials. So it's a very, very small portion, again, about 1,000 square feet in a 300,000 square foot building. And then I think most importantly, the mitigating factor of this safety plan, this containment plan, to ensure that the operation of this facility does not rise to the level where it may be considered a use that is toxic, lethal, hazardous, dangerous, or injurious to the general welfare. So with that said, I think there is a good planning rationale for the board to move affirmatively on the interpretation that the use itself is within the confines of its permitted use and not within the confines of a prohibited use here. Bearing in mind, light industrial manufacturing is a permitted use. You heard through Christine's testimony that this is going to operate as a logistics warehouse facility, again, with that cross-dock component and that relatively short duration. I think that does hit the intent of the zone plan. And again, the board can move favorably under subsection 70B powers that the use is permitted in the zone. In the alternative, to the extent that the board finds that the use is not a permitted use in the zone, I think the board can move favorably on the application under subsection 70D, as in David, in the land use law, which gives the board authority to grant relief for uses that are not permitted in a particular zone. We have some good case law here. The Medici case has been out there for 40 plus years that defines and clarifies the statutory criteria for grant of use relief. Essentially, there are 4 elements there. The first element of proof under Medici for use relief looks at site suitability. And I think based on the site location, and I'll show some aerials in a little bit, some fresh drone shots. But this site is centrally located within a vast industrialized area that I'm sure you all know well, that has established itself right by the New Jersey Turnpike. Christine gave you the reasons why this use belongs here and why the nature of these uses belong here. Next to, I think, the second largest airport on the East Coast and the largest seaport on the East Coast. And then more than half the United States population is within 24-hour reach of this particular location here. So that's credit to our road network that's in place and why logistics is so important to the New Jersey economy and why it has manifested here. That goes towards site suitability. And of course, not only the central location within the context of an industrial area, but also the generally centralized location within the building itself. As you saw through the architectural plans, this confinement space is in the middle of what would be otherwise, I'll say, ordinary warehouse or storage of goods operations. That's the first part of Medici. The second part looks at not the land itself, but the land use law and the purposes of zoning that are the reason why we can zone in the first place. And I'll turn to purpose A in the land use law as being advanced here, the promotion of the general welfare, again, with a logistics use that is going to operate substantially in conformance with your ordinance, if not entirely within the confines of your ordinance. And in that regard, will deliver a beneficial logistics type of operation that brings goods and products to the consumer population where we know demand is high. Third part of the test now looks not at the site itself and not at the land use law, but the surrounding land use context and whether the operation can be granted without creating substantially adverse impacts to the public. As you heard through the architectural testimony, this operation is going to meet all applicable building codes, including the UCC and the fire code. And we think that layer of protection is there to safeguard any negative public impacts. And then finally, again, if the board is to move on the use aspect here, I think we can certainly find that if the use is not wholly permitted in the zone, then it is certainly akin to what is permitted in the zone. And I would offer that the degree of departure from the zone plan is not substantial here. And I think the board can move favorably on use relief related to a particular site and based on particular evidence and testimony that you have heard. This is not tantamount to a rezone that's going to open up a floodgate of hazardous warehouse facilities in the area. It is going to remain an S1 category building. And in that regard, I think the board has good, solid basis of evidence and testimony to support the relief that the applicant is seeking. So again, under 70B or 70D, I think the board has enough evidence here to move favorably on the application. And Luke, I don't know if you want me to put this on. You want me to show those aerials that we took today?
Yeah, let's introduce those as Exhibit B. We did send these to the board secretary right before the meeting, but I don't think they've been posted online yet.
Okay. Looks like it made its way on the screen here, but again, we're just showing you the 4 photographs taken today to show the physical characteristic of the site itself. Again, a modern contemporary warehouse facility, which is exactly what the zone wants to provide. This is the quote from the zone: to provide sufficient space and appropriate locations for attractive, modern landscape industrial complexes, which do not create hazards. That's the long and short of it. And I think we can see how neatly and cleanly this facility is operated. This is a view to the northeast with New York City right back there in the horizon. Again, the newer facilities that have emerged here and the positive transformation, kudos to good planning. This is a view looking to the southeast. This is a view to the southwest, and then finally a view looking to the west. The main emphasis here is that it's a neat, clean, well-maintained, well-organized facility. Nothing about what the applicant is proposing here will change that or erode the quality of the building. And with that, I'll pause.
And I have no additional questions for you on direct. Open it up to the board and its professionals. for questions.
Thank you. Mr. Dupont, you're up first. Any questions of the expert witness?
I think once the applicant completes their case, Mr. Chairman, I will provide my input.
Okay, thank you. Counselor Jardine, do you have any questions of the expert witness?
Yes, Chairman, just briefly. So, Mr. McDonough, I just, we talked about with the prior witness, the 21 building code and the chapter that you were going to provide me the citation for. And that provides for certain, language with respect to percentages of the building used for hazardous, right? To determine whether or not it's hazardous or not.
Yes, and I can give. Okay, I'll let.
I'm sorry, I got it cleared up. The pieces that it doesn't mean that those pieces of the building are not hazardous, right? We have to classify each piece of the building as its use. When it's an accessory occupant, which is section 508.2 of the IBC, when the aggregate of all the non-main uses, which would be the business use and the, we'll say, high hazard use, H3 use, are less than 10% of the total area of the building, which in this case, 10% is 30,000. We are only at like 9,000, 10,000 square feet. Then all of the other requirements of that code will comply with the S1 building use, which means the areas that are allowable, the heights that are allowable, and all that. But the fire protection features and the life safety features and separation from those spaces still need to meet the code for the high hazard use.
Okay, yeah, I just, okay, and then, so with respect to that, so there's a less than 10%, more than 10% dichotomy there, but Mr. McDonough, with respect to, the borough's land use ordinance, which of course was written by the governing body and reviewed by the planning board, not by this board. So this board has to follow what's written by the governing body. It doesn't, in section, in that section that you referred to, 160-35 G6, it doesn't make that distinction in those specific terms. It doesn't talk in percentages of use or anything like that, right?
I'm going to let John handle that.
Making sure I'm not muted. Yeah, the answer is no, it does not. Again, the language reads what the language reads. It's somewhat discretionary. Any use which may be toxic, lethal. I think that's the charge of the board to make that determination if it may be lethal, hazardous.
Right, and then you added some additional qualifiers. You said, because of the short duration, because of the very small space, and because of the mitigating factors of the containment plan, you don't view the use as prohibited under that section, subsection 6, as a result of those three factors.
That's right, that the use remains a use that is contemplated within the zone scheme because it is not a use which will be toxic, lethal, or hazardous in terms of its operation.
I just want to clarify that this code section doesn't write in those other qualifications, the duration, the location, the space, that sort of thing, right?
It does not.
Okay. Thank you, Chairman. Nothing further.
Thank you, Counselor. This time I'll open up to our board. Does anyone on the board have any questions of this expert witness? If you do, unmute yourself. Anyone on the board have any questions? Hearing none, I move to the public. Is anyone in the public have any questions of this expert witness? If you do, please unmute yourself and ask. One more time, anyone in the public? Hearing none, closed to the public. Counselor, please proceed.
We have no further witnesses on direct at this time. So I defer to the board if you have any additional questions, or if you have any new testimony that you'd like from us.
No, I think I'm satisfied and the board is satisfied with the testimony. If you want to surmise what you're looking for and see if we could help you.
Sure, I appreciate that. So again, this is an application that has a few different aspects to it. The first part, which we just discussed a bit, is an interpretation of the borough zoning code, and specifically that's section 160-135. And within that code, we're talking about G6 really, and in determining whether or not this is a prohibited use given the introduction of the storage of materials that in the quantities being stored count as a H3 high hazard. And if storing those materials brings this property out of compliance with the permitted uses and requiring a use variance. So the first part is the code interpretation. I think you've heard great testimony from our applicant and our professionals about how the storage of those materials is very limited and is a minor part of the overall business and the use of this property. And that it is centered in the interior of the building. It does not change the overall classification of the building from an IBC perspective. And it really is an accessory part of the overall use of this building, which remains the storage of materials in a light industrial use. If the board does not agree with that interpretation and decides that this is in fact a prohibited use requiring a use variance, I think you've heard very substantial and supportive testimony about the operations on site, how this site and property is particularly suitable for this use given its location within an industrial complex on the western side of the New Jersey Turnpike. The location of these materials within the center of the building to avoid any outside interference, and that this is really an appropriate use of this building on this property, and that the board can grant that use variance without any detriment to the zoning plan. We're also here seeking the minor site plan approval to permit the improvements that are proposed within the interior of the building to construct the 3 control rooms. You've heard from our architect that will comply with all building codes and fire codes, and that otherwise the applicant will be complying with borough ordinances and looks forward to being a resident of the borough for a long period. So we do ask that the board act favorably on this application with respect to the code interpretation and minor site plan. And in the event that the board decides against us on the interpretation, we do respectfully request that the board grant the use variance requested.
Thank you, Counselor. I can see both testimonies and Mr. Dupont, what would be the proper way to proceed with assuming the board agrees with this?
Well, here's a couple of things, Mr. Chairman. I'll put a couple of different hats on. First, from a zoning standpoint, just so the board knows, this property has current existing violations and I believe fines for housing this material in this warehouse. Right? This was materials submitted, stored in this property last year that our fire department, while doing an inspection, identified the material. Right? This is an applicant coming in asking to put materials in. They have materials in place. The fire department violated them, and there's currently violations and fines. That's one. When it was submitted to the board, and it came from the building department and from the fire department, and the applicant made application to us, from a zoning standpoint, it's clear. Our zoning ordinance doesn't talk to percentages of hazardous materials. It's H3 hazardous materials, not allowed in LI zone. It's pretty clear in the ordinance. It doesn't matter if it's 1%, 40%, 100%. It's not permitted. If it was ancillary to that use, it would say cleaning products used to clean portions of that building. Perhaps there's a case. From a zoning standpoint, I don't think there's any doubt they need a use variance. We reviewed it a couple times, we reviewed our professional staffs. I think it's very clear that they need use variance. They could avoid the use variance, they could just get rid of that material in that building. It's easy. If it's such a small part, they could certainly eliminate it going farther. Now, assuming that is they require a use variance, you heard some good testimony from, now I'll put a planning hat on. You've heard that it's a smaller part of the building. It is. Mr. McDonough is absolutely correct in his planning assessment. They will have to meet all the building codes, all the fire codes. They get approval, if they get approval tonight for the use variance, they're not putting this material in tomorrow. They're submitting for permits to our building and fire for reviews. So I think from a planning standpoint, the use, I think we're an industrial town. It's a light industrial zone. It's a very limited product. I can see support for that. And if I put the third hat on, your engineer, site plan is very minimal. Just that they have to, applicant has to know they're not putting, I'm happy to hear that all material is out of the building now. That's a big step. They're not putting material in here tomorrow. They're submitting for permits. They're rectifying all their violations and fines. This will not eliminate any of those. And they'll have to get complete process permits. And they'll have to comply with all our fire and building department. So although it's a lengthy thing, Mr. Chairman, I think they clearly need use variance. I think there's a reasonable case to say they can get the use variance, but they do have to comply. There's a couple outstanding things here they're going to have to address moving forward if they want to actually put the product in. And that's all I have.
Thank you, Mr. Dupont. Mr. Jardine, would you like to comment on Mr. Dupont and see where we can move forward here?
Yes, and Chairman, I do want to say one thing. Typically, we'll allow questions of the witnesses after they, by the public. We'll open it up to the public for questions of the witnesses. And then at the end, we usually open it up for any comments of the public. Pretty certain there's no public on, but I think we should probably make sure if anybody has any general comments in the public.
Sure, we could do that. I did open up to the witnesses, but yeah, at this time, first I'd open to the board. Is there any questions on this application that anyone would like to have of this application? One more time, I ask if there's anyone that on the board that would like to be heard. Okay, hearing no one, I'll close to the board and open to the public now. Is there anyone in the public that would like to comment on the testimony and the application? If you're there, please unmute yourself. I'll ask one more time. Anyone in the public? Hearing no one, I'll close to the public.
Thank you.
And I'm sorry, Mr. Chairman, just so you know, with Chief Harushka, I asked him to be on the call. Department, he's available for comment.
I appreciate that. Thank you, Mr. Harushka. If you have any comment or you'd like to back up Mr. Dupont and his summation, please do.
Yes, thank you, Mr. Chairman. We did the inspection out here and the cause for this proceeding and also the initial fines and violations that we submitted. We found tens of thousands of gallons of flammables and combustibles within this structure when we were out there. This isn't over a couple of 5-gallon pails. They had totes, 250-gallon totes, pallets and pallets of 55-gallon drums. So if that is their normal stock, I don't see how these cutoff rooms are going to suffice and get them where they need to go. However, that being said, they did remove the highest hazard. They were out on an imminent hazard, removed the highest hazard goods and got them out of the building within a 24-hour period. They still, as of today, have poisons, flammables, poisons, combustibles, some explosives, and caustics and corrosives that are in the building today, which is definitely not something that they're permitted to do in their current fashion. They also have an impound area that they have stuff that comes in and out for the military and for customs that has its own components that are hazardous materials that come in and out of there. So it's not just this small area that's being outlined by the professionals, at least not what I've seen on multiple occasions. So this has got to be addressed. If they plan on reducing this stock so that it fits in these rooms and they're not going to have overflow, that's one thing, but we have never witnessed the small quantities that they were reporting in their proposal.
Interesting. Thank you, Mr. Haruska. Counselor, do you have anyone on your team, your witnesses that want to address Mr. Haruska's concern?
If I could have about 30 seconds to just speak with my client to see who would be best suited to address that, that would be very much good. But I guess.
Thank you. Yes, please.
Zoning for the past hour.
Donnie, mute yourself.
Yeah, I'm gonna have to excuse myself, Brother Chairman. There, I don't have enough. Yes.
I appreciate your patience. I'm going to recall Christine Claremont back to provide an answer to that question and statement by the chief.
Yeah, I mean, from the data that I pull and from the visits that I've had, there definitely is, ongoing hazardous freight material that passes through the facilities. Like we said, the H3, the drums, the H3, I guess, the high hazard, those have been removed from the inside of the facility and onto the outside. But I'm not sure, based off the visits from Pruska, from Chief Pruska, where there had been, I guess, higher quantities that have been there at the moment. I don't think that's part of the normal part of our business. I mean, everything should be contained in that one area. There is that section with the MOD, which most of that by this point should have also been moved for anything hazardous within the zones of where the sprinklers were put. And again, I'll just make sure to verify with the team that we're, doing things in accordance with how the structure is set up. But for the amount of cargo that we move through in any reporting that I've run, the amount of what we call dangerous goods or what we would, classify as hazardous material, whatever the class might be, is typically very limited.
And you can confirm that any materials that are in quantities that constitute an H3 classification will be stored within the two control rooms that Mr. Davidson had pointed out that will be specifically constructed for H3 materials, correct?
Correct. And I think it's the H3, the high quantity of the drums. And I guess, unless Joe, correct me if I'm wrong, but there could be some small quantities of class 3, which wouldn't necessarily qualify under the H3 high hazard. It's really just the large drums with which, Chief Pruska, that was, one of the main findings of your initial visit.
It's not just the large drums, it's the total quantity of those classifications. It doesn't matter whether they come in totes, drums, or small packages. It's the total gallons that you need to comply with. And again, these quantities that we're talking about being in excess of essentially are the, we'll say the minimums you know, till once we exceed them, that's what it's classified as the H3 use.
Yeah, okay.
Otherwise, it can be still stored within a control area based off of the building code and not necessarily be classified as an H3 use. It's just when they exceed that quantity limits in the building code, fire codes, that's when we kick into a high hazard. And that's why we're here.
So I'll certainly make sure that we're looking at some of those smaller non-drums of the class 3, just to also ensure that we're, you know, not exceeding any quantities. Otherwise, they also need to be removed from the interior of the facility as we, you know, continue to sort this out and identify what's the path forward. Do we remove it all? Do we do the use variance? Whatever the board decides.
And Chairman, just on that point, and maybe this is for Mr. Pontier, I just want to make sure that, so there are pending violations currently, correct?
That's correct.
Okay. And I want to make sure that if the board provides you with a use variance for this, that is not in any way a waiver or a sign off on those violations so that those go away, right? You're agreeing that those still remain, and that of course you're going to pursue with respect to that.
Yes, my office is not handling the violations, but I understand that there are violations out there. We do not see this as a resolution of those violations, and I believe that my client and the applicant, will remain committed to addressing those violations and seeing through the appropriate process.
Okay. And then additionally, I mean, one typical, as I'm sure you know, typical conditions that we append toward the end of a resolution, one of which is that the applicant, the approval is conditioned upon, all other approvals that may be obtained either from inside the borough or outside the county or state, federal, whatever it is. And you agree to that as a condition of approval.
Yes, we understand we'll have to obtain all outside approvals in addition to, I believe it was fire and building that were listed in Mr. DuPont's memorandum.
Okay, and notwithstanding what the board may approve tonight, that you're still subject to any other laws or requirements or ordinances or regulations, state, federal, county, local.
Yes.
Thank you.
Yes, that's going to have to be part of the resolution in order for them to obtain what they're looking for. They're going to have to make sure that all of their permits, fines, taxes, everything are paid to date.
Correct.
All right, so granting you a resolution is pending. If we go down this road and we have the vote and you're successful, you still have to comply.
Yes, we understood.
Mr. Haruska, anything else?
No, Mr. Chairman, I believe that takes care of everything on my end.
I understand your concerns and you're looking out for the safety of the people that work there and the public and the people of Carteret. I think I'm going to allow Mr. Jardine to tee this up for a vote, and assuming this resolution goes through later and everything's in compliance, your organization, the fire department, will be doing yearly inspections and keeping on top of this client, right?
Yes, understood.
Yeah, and Chairman, and this motion is a little bit, tricky to tee up because it is a two-part thing. I think it's worth reiterating to the chairman and the board that you can decide, the applicant's requesting a determination that the use is prohibited and is permitted in the LI zone. And you can decide that the use is actually prohibited based upon our LI zone regulations, but you can thereafter approve a variance that they're seeking variance so that they're allowed to do what they're intending to do for this zone. And you've heard the planner go through the proofs under the familiar D1 test as to why the use is particularly suitable for this location. So I don't know what the board's pleasure is, but the motion would include first whether the interpretation is that the use is prohibited or permitted in the zone, and then if you decide that the use is prohibited, then you can decide to approve, deny the use variance based upon essentially the planner's testimony. So that would be the motion.
Yes, Mr. DuPont, what course would have more teeth for you and the borough on this particular application? I'm inclined to work with this tenant, assuming that in the future they work with the fire department to keep the building and personnel and people of Carteret safe. But I want to be sure that whatever we grant here, we still have some teeth in it.
Mr. Chairman, I've heard nothing tonight that would change my mind that it is a prohibited use. There's nothing that changed my mind. I think the zoning determination that is not permitted is just as valid as it was 2 hours ago. So that being said, that would be your first motion. And then second, to approve use variance, then we do have the ability to inspect. Look, it's going to be to keep them, to monitor it, it's going to be difficult. But if you give the use variance and we allow them to put this material in, I assure you, Chief Rushkin and his department, as well as the building department, will keep close eyes on this applicant.
Yeah, I have no doubt of that. And I think I agree with you that there is no reason we need to decline it and look towards the variance. So I'm going to put to the board a motion to deny on the first portion, and then we can move on to the next. Let's see if we can get through this. Counselor?
So, Chairman, the motion would be that the interpretation of the zoning officer that the use is not permitted is the correct one, and deny the applicant's request to interpret the ordinance such that it is a permitted use. So you'd need a motion to uphold the zoning officer's determination.
Okay, at this time, I will make the motion. I need a second.
And
Voting, someone on?
And I guess we should clarify that voting yes on the on this motion is agreeing that the use is not permitted.
Correct. So I'm making the motion, and do I have a second from the board?
Second.
I second.
I have a second. Lauren, can you please poll the board?
James,
Yes.
Helly,
Yes.
O'Connor,
Yes.
Chen, Patika.
Yes.
It's been approved.
Thank you, Lauren. All right, Mr. Jardine, we have the second part of this application. You want to give us the parameters and tee that up?
Yes, Chairman. The second, it sounds like the board is in favor of granting a use variance here. And that use variance would be subject to all the conditions set forth in Mr. DuPont's March 18th, 2024 planning memo. In addition to that, the additional conditions of the applicants agreeing that there's no waiver of any fines or penalties as a result of an approval of this use variance, and that the applicant is required to comply with all other laws and regulations and pay taxes up to date and all the typical conditions that we require. So a motion and a second to approve the use variance application for the applicant's proposed project.
Thank you, Counselor. I will so move it. Do I have a second from the board?
Second.
I have a second. Lauren, would you please poll the board?
James,
Yes.
Helly,
Yes.
O'Connor,
Yes.
Chen, Katika.
Yes.
Okay.
Thank you very
Okay.
much, board.
I congratulate you, gentlemen. Thank you. Thank you for your testimony and everyone, ability to get through this evening. This is a little out of our wheelhouse. We haven't seen this in the way, shape, and form that it was presented. Mr. Haruska, I thank you for your professionalism and keeping an eye on the employees and the residents of Carteret, making sure they're safe, and look forward to you keeping an eye on this particular tenant and making sure that they comply with everything that's in the resolution and what's by code. Do we have any further business to come in front of the board this evening?
Nothing.
Anything for good and welfare?
Nothing.
All right, I just want to say thank you, everyone, and appreciate you helping us get through this. Mr. Jardine, you'll set up the resolution for signature, I presume.
I will, Chairman. We'll adopt it at the next meeting.
Yep.
Great. Thanks again.
Thank you, everyone.
for your time.
Thank
Meeting
you,
adjourned.
everyone. Take care. Have a good night.
Thank you.